you very much. Please be seated. We'll go on the record in the matter of State of Utah versus Martin MacNeill. He is present with his counsel. The state's attorneys are present. We are outside the presence of the jury. Counsel, would you like to speak to the issue we dealt with at the bench? Go ahead, whoever's first.
Honor, after reviewing this, I don't think the statute addresses our exact situation specifically, nor does it deal necessarily with the issue of admissibility, but I think it does address it by way of analogy through the discovery process, which is if it's in a case of prescription fraud or Medicare fraud or Medicaid fraud or something like that, it is discoverable and the state is then authorized to send that to defense counsel. I think any other context under 601 is inadmissible to share that information, and certainly making it an exhibit and publishing it would be sharing that information in the state's mind. I'm uncomfortable with it coming in as an exhibit.
Could I just ask this question as I think about the context of the case? There will be testimony, or has been, there will be testimony that Michelle MacNeill was a drug-naive person. I don't know what the database material shows. I suspect that it will show that she is not that, or she has had medications prescribed to her in the recent past. And if that's the case, clearly it would go to the heart of a claim or defense, and I'm wondering if the due process clause would, that as applied, that this limitation on access as applied would violate the due process clause, since that would be Brady material, essentially.
I believe the substances were from 2002, so the relevance is, in the state's opinion, marginal. We aren't objecting to counsel asking Mr. Mickelson about it, and if it refreshes his recollection in any way, I'm fine with that. I think they have the right to present their defense, and we will argue that this is not really relevant for a number of reasons our toxicologist will address. But in terms of making it an exhibit, that's where I have my most concern, Your Honor.
Is there could you make a proffer of what the toxicologist will say about who constitutes a drug-naive person?
I'd probably have to leave that up to Mr. Perkins.
I can make a rudimentary one, Your Honor. I think they'll testify that someone who has built up, that when someone takes a drug routinely, certain types of drugs, particularly opiates, the receptors in their nervous system adjust with certain chemicals that transmit the signal that the opiates are blocking. And when someone adjusts, or excuse me, when someone's body adjusts to a routine dosage of a drug like an opiate, that adjustment makes them tolerant to it and makes the effect less pronounced on them. However, if someone has not been taking the drug routinely over a period of time, they're no longer tolerant. Their body readjusts back to the normal status. And so in this sense, drugs that were prescribed in 02 or 03 and not taken regularly up until April of 2007, there really wouldn't be a drug tolerance there. And if she were not taking those drugs regularly, she would still be a drug-naive patient despite the fact that she'd been prescribed those drugs earlier in her lifetime. Similar to when a heroin addict goes into jail for 6 to 9 months and comes out, they no longer have the same tolerance and are higher risk of overdosing.
All right, thank you. From the
one other issue.
Yeah, go ahead.
A couple other concerns I have, and as a prosecutor, I have charged a number of controlled substance violations based on a Doppler report that proved to be erroneous, and these people actually had prescriptions for some of the things they were charged for. And so I don't know that the Doppler report is the best evidence anyway. Certainly, Mr. Mickelson can testify about it, but it's the Doppel database is routinely mistaken on some things, and so those are some of my concerns.
I appreciate that. Thank you. Go ahead. Could I see it?
Yeah.
Yeah.
Get a clean.
Okay.
That's the report as it was provided to us, Your Honor.
What is Mr. Mickelson's responsibility?
He's a nurse practitioner.
And he can't, so he can prescribe?
Yes.
Who will lay foundation for this?
It's my understanding we have a stipulation on foundation, and the question is admissibility for the statutory reasons that the state has addressed.
I don't object to that being the Doppel report for her. I think that's the truth.
Is your concern that Mr. Mickelson won't remember these prescriptions, and so?
Well, that's part of it. He didn't remember them, and so we have shown him that, but we want this report in for a number of reasons. And we think that it is relevant both to indicate that Michelle isn't exactly drug naive, and also to indicate that back in 2003 that she was prescribed Lortab and Percocet together within approximately the same time frame that she was also prescribed Valium as well. That in 2006 she also was prescribed hydrocodone. Back in 2002 she was prescribed hydrocodone. And then in August of 2006 she was also prescribed Ambien. And so there will be some testimony. There'll be some testimony in this case, presumptively, from Alexis that her mother hated to take medication. And we think that this is some evidence to show that that's not the case.
Do you have any, will you be calling an expert witness to testify about the issue of tolerance?
We have an expert who has been designated that if we call him, he will testify about tolerance.
What will he say about a controlled substance prescription given in 2006 for hydrocodone? Would that render a person no longer drug naive in April of 2007?
I think that he will say that's a tough question to answer, that determining whether how somebody's body will respond to a medication is something that is very subjective, and something that you can't simply tell by ascertaining whether or not they've ever taken a medication before. And so it's, as I understand his testimony, it'll be that there are a lot of factors.
Is prior use between 5 and 1 year earlier one of those factors?
I believe that that's one of the factors to consider, yes.
Even that old?
I don't have a specific recollection to say exactly what he would say on that point. My recollection is that he will say that there are a lot of factors that must be taken into consideration, which does include prior use as well as other subjective factors for each person, their age, their gender. Prior use is one.
Mm-hmm. So in summary, your position on relevance is that it goes to the issue of whether or not Michelle MacNeill was drug naive, and also to the issue of whether or not hydrocodone and diazepam should be prescribed together. And Percocet together. Is there any real issue about that?
Yes, I think that the prosecution's theory includes in part that my client, Mr. MacNeill, looked at the PDR and came up with some theory of medications that he wanted Dr. Thompson to prescribe, and designed a potent cocktail that they think may have caused death.
I understood the state's witnesses to say, yes, as a matter of routine, we do prescribe these drugs together. That's not an issue. Yes, they can be dangerous if taken all at once, but we do prescribe them together. Have I misunderstood that?
I believe that that's what the witnesses that have testified thus far have said.
Am I going to hear something different from someone else?
The toxicologist, Dr. Dawson, describes the circumstances a bit differently, and describes it as a potent cocktail of drugs.
Okay.
And so I think this is critical to our defense to show that a good portion of what is called a potent cocktail of drugs has been prescribed to Michelle in the past, that she wasn't naive in the sense of taking medications because she had.
And that's using the term drug naive a little differently. And that's a third area of relevance, that she herself knew how to take these medications safely.
That's where I was going, yes.
Okay. Used not in the terms of a tolerance issue, but her own personal knowledge. Okay.
That assumes she took the drugs that were prescribed to her as well, right?
Okay.
This case is full of circumstantial inferences that both sides of the sequence. And, Your Honor, as you mentioned, under due process, where the statute doesn't prohibit this report from being admitted. It deals with dissemination. In this case, it has been disseminated to the defense.
Yeah, and in my view, appropriately so, even though it doesn't relate to a defendant in a criminal case, which is the access permitted by statute. I think clearly under the Constitution it's exculpatory and would need to be disclosed under the Due Process Clause. I think the state has appropriately disclosed it.
I do too. And to to now say that it was appropriately disclosed, but you can't admit it, I think would be
Yeah.
a due process violation. And I hope that we've established sufficient relevance that Your Honor will allow us to.
Read, as the statute reads, it would suggest that the only time the state prosecutor could disclose information from the database in a criminal case would be when the information is about a criminal defendant for the purpose of establishing a defense. And I think at least in the context of this case, the evidence is exculpatory when taken in context, and I think the state has appropriately disclosed it under the prosecutor's constitutional obligations. Do you wish to be heard any further?
The only other thing I want to add, Your Honor, is that I didn't understand the multi-purpose approach to this admissibility. I thought it was to refresh Mr. Mickelson if his memory of it was different from what Doppel would have recorded. I didn't understand we were getting into this whole thing, and so I'm frankly not prepared to address that, and I would prefer to deal with the admissibility for everything she's been prescribed previously in a different way. When it comes to Mr. Mickelson, I think he's more than capable of testifying to what he did. In terms of the whole document coming in through him, I again would object to that.
So you do not have a stipulation on foundation then?
Well, I'm in a tough spot because I told Mr. Spencer I agree this is what Doppel has produced. I thought it was for the limited purpose of refreshing Mr. Mickelson of what he had done. And so if it's to bring in the other things, I would object to those at this point.
Let me ask this. Do you need this document today to examine Mr. Mickelson, either of you? Do you need it today?
I need it just to refresh his memory. I mean, it doesn't necessarily need to be admitted today, but I would like to talk to him about the document.
My concern then is if all you're going to do is say, does this refresh your recollection, he can read it, then take it from him, and he can testify from his memory. But if he says, no, it doesn't, then we're back to where we are right now. So, Mr. Peed, you said you're not ready. What more do you need?
I want to review, for example, Your Honor, we have records from, is it Shopco or Target? And I want to review because, again, my concern is that the database is just simply not kept up as responsibly as it should be. I want to review each of those future prescriptions against what other evidence we might have, just in terms of accuracy.
Right, does that go to its weight, though, rather than its admissibility, and we would look at those other, you may demonstrate that it's wrong.
Sure, and similarly, I'd want to talk to someone about the limits and such that it entails.
In terms of data entry?
Correct.
No, and I don't want to make this a trial about the state's database.
Sure.
I think we need to think carefully about, we don't want this trial to turn into a mini trial about the state's controlled substance database. What I will do is reserve ruling on the admissibility of, can I just mark this? Is it Defense Exhibit D? I'll reserve ruling on Defense Exhibit D, allow you to use it today to refresh his recollection with the limitations we've talked about. I don't want him to take the document and begin to read off it. He can, orally, read it out loud. But he may look at it, read it, see if it refreshes his recollection. If it does, great. Take the document from him. He can testify from his own memory at that point. If it doesn't refresh his recollection, and I suspect that it may not, given the number of prescriptions he's probably issued, at that point, let's take a bench conference and we'll decide where to go from there. It may mean that Mr. Mickelson's testimony will have to continue tomorrow. when we have some more time to talk from that point forward. Let me provide this back to the defense. For the record, the defense has offered into evidence a report from the Department of Professional Licensing Substance Database. Access to information from the database is governed by statute, Title 58, Chapter 37F, Part 3. Under the statute, state prosecutors may receive information from the database so long as they are engaged in a specified duty of their employment in enforcing laws, regulating controlled substances, investigating insurance fraud, Medicaid fraud, or Medicare fraud, or providing information about a criminal defendant to defense counsel upon request during the discovery process for the purpose of establishing a defense in a criminal case. In the context of this case, the information from the database does not relate to a criminal defendant, but rather the alleged victim of a crime. It would be offered for the purposes stated by defense counsel. First, to demonstrate that certain medications at issue in this case are prescribed together. Second, that Michelle MacNeill was not a drug-naive patient and may have had a tolerance to certain medications. And third, to show Michelle MacNeill's own personal knowledge of how certain medications might be taken together and safely. Given the state's theory in the case, the information from the database does constitute exculpatory evidence, which, despite the narrow reading or the narrow language of the statute, I believe the state properly disclosed to defense counsel pursuant to its obligations under the Due Process Clause. Whether or not the report from the database itself is admissible, I'm reserving on, and you may examine Mr. Mickelson in the way I've indicated. Let's have the jury brought in. Thank you. Please be seated. We're back on the record in the matter of State of Utah versus Martin MacNeill. He is present with his counsel. The state's attorneys are present. Thank you for your patience. I'm sorry to have kept you. We have been working in your absence so that we can move things forward expeditiously this afternoon. You may call your next witness.
They call Steve Mickelson.
Mr. Mickelson, if you would come up here to the clerk's desk, please raise your right hand and be sworn. Thank you. Would you be seated here and respond to council's questions?
Will you please state your name and spell it for the record?
Stephen Mickelson, STEVEN,
And how are you currently employed?
Utah County. I am a division director for Utah County.
In what capacity? What is your training in?
Oh, nursing, advanced practice nursing,
And if you were to describe your profession, what would you say that is?
nursing,
And you're a nurse practitioner.
that's correct.
How were you employed in April of 2007?
As a nurse practitioner, the first part of April as at the Utah State Developmental Center, and later on for the Department of Health for the state.
So initially in April of 2007, you worked at the Utah State Developmental Center, and during April you moved to work for the county.
Yes. Excuse me. I worked for the developmental center and I moved to the state.
Oh,
Since then, I've gone to work for the county from the state.
okay. How long did you work at the Utah State Developmental Center?
From about August of 1996 as a nurse, and then my advanced degree, I started working as a nurse practitioner about in the fall, September or October of 2000, and then I finished up there in April of 2007.
So you worked there 11 years in a capacity of either a nurse or a nurse practitioner.
Yeah, that's about right.
Do you know the defendant, Martin MacNeill?
I do.
And how do you know him?
He was my supervisor at the developmental center from about the fall of 2000 until I left in 2007.
So at about the time you became a nurse practitioner, the defendant was your supervisor.
That's correct.
And what was his job position?
His job was to be the medical director for the facility, as well as my supervisor. As nurse practitioners, we would see patients and he would supervise us seeing patients.
What was the nature of your relationship with the defendant?
Like, how we got along?
Well, no, in terms of, was it entirely professional? Were you also friends on the side?
For the most part, it was strictly at work. There were some times where I would be asked and invited, and I accepted to go to like a benefit for the ballet or something along those lines, and we on occasion did that. There's also some side work on occasion that I did in relation to Martin MacNeill. So.
Okay. What was your relationship like in terms of how you worked together?
I think we worked good together for the most part. He has a very strong personality. I didn't give him reason to be defensive, but I knew that was something that I had to manage. You swim through, rough waters. You just approach it differently.
So the two of you got along?
I think so, yeah.
Okay. What was the nature of your work at the developmental center?
I was a primary provider for people with disabilities, but primary meaning sore throats, pneumonias, things like that. There is also specialty care that's given there in the lines of neurology and psychology, psychiatry, and I, for the most part, stayed out of those as much as possible. We treat the primary care issues, the things that you would go to the doctor first for. Am I making sense on that?
Let me see if I can clarify. So you're saying you were basically a treatment practitioner provider for these people?
Yeah, for basic treatment, general treatment.
And you said it was the defendant's job to supervise you and others in terms of their medical care.
Correct.
Are you familiar with the term codes or coding?
Sure, yes.
What is that?
If a patient or a resident in this case were to, their heart stop beating or they stop breathing for some reason, it's common practice in the hospital to call what they call a code. And essentially that means life-supporting measures need to be emergently attended to. Otherwise, this person is on their way out. They're dying.
As a nurse practitioner at the Utah State Developmental Center, did you have the opportunity to attend code or coding scenes?
I did,
Did you attend any of those code scenes with the defendant?
yes.
How were those code scenes handled?
I think for the most part, you know, you consider,
I object, Your Honor, in this comparing to habit evidence of how it's generally done and comparing to other CPR scenes.
What's your objection? Your rule objection?
The rule objection is, it's the habit evidence, relevance, 402, 401.
What's your response? I'm sorry, go ahead.
I'm not sure what the rule evidence is for habit evidence, but trying to compare Mr. MacNeill's habit in performing CPR is not admissible.
Go ahead.
I'm not bringing it under habit. I don't think I've established anything near a habitual foundation. I think it's highly relevant to him having attended these scenes previously and the way that he acted when Michelle was under a similar situation.
When a patient is, I'm sorry, you said Michelle?
Well, when a patient is on these situations
And-
as compared to that.
So are you offering it to show the defendant's knowledge of life-saving procedures?
That and his, yeah, that's,
Overruled as to relevance, it's not offered as habit. You may proceed.
how were those rescue attempts or code scenes with the defendant handled?
I think as a general rule, they were handled well, considering that it is always a chaotic, it's always a stressful situation when you are faced with somebody not breathing in front of you, and when you're trying to perform life-saving measures on them, we go through regular training to make sure that, you know, you open an airway, make sure the heart's pumping. If it's not pumping, you pump for them. That's what CPR is. For the most part, I think they were handled quite well.
Do you remember the morning of April 11th of 2007,
Yes,
specifically around noon or just before noon?
yes.
What can you tell us about that?
Well, I was returning from my duties in one of the outside buildings away from what we call medical services, and I had been seeing patients. So I had returned to my office, which is in the medical building, and not long after coming back to my office, one of my cohorts came to me in the hall in a rush, said something's wrong at the MacNeill home. I'm in a procedure, will you go? And from that, I drove to the MacNeill home. It's not too...
I'm going to stop you real quick, sorry. Who was this coworker that told you about?
Jim Van Zant.
And so based on that, what did you do?
I got in my car and went down the road. I knew that they lived in a neighborhood that was a gated community. I hadn't been in the gated community, but I knew that I knew the approximate location of the home.
So you had not been to the home before.
No.
Were you in a hurry? Were you going pretty fast?
Yeah,
How long did it take you to get there?
I would say 2 to 3 minutes. It's not 2 to 3 miles from the developmental center, I would say.
Okay. What did you see when you arrived there?
When I arrived, there was multiple emergency vehicles. I remember an ambulance. I remember police cars. I don't remember exact quantities. I'm trying to think if there was
Are
a
you
fire
saying,
engine there.
if I could stop you again, I apologize. Are you saying that the ambulance was there when you arrived?
It was.
So you arrived after the ambulance?
As I kind of indicated before, I had never been to their home, so I didn't know which home was theirs. But upon arriving in the neighborhood and seeing all of the emergency vehicles, it was pretty apparent which home was the home in question.
Did you see the defendant there?
I did.
And did you speak to him?
Yes.
What did he say to you?
He said, go inside, help. Michelle's, I don't remember if he said, Michelle's in the bedroom or something like that.
So what did you do?
Went in the front door. Could see there was a little commotion to the left, so I went left where I could see that I was entering the master bedroom. And upon entering that, I saw, I want to say maybe 4 EMT paramedic types that were working on a body that was Michelle.
Prior to this, were you familiar with what Michelle MacNeill looked like?
Oh, I knew Michelle from like the ballet benefits and that.
So from the benefits and such, you knew what Michelle looked like?
I could recognize her face, yeah.
And could you recognize her there being worked on?
Yes.
How did she look?
She looked pale. She was completely unclothed. She did not look like they were working a code. That was quite apparent. She had a gash above one eye, like along her eyebrow.
Did you notice blood in the area?
You know, surprisingly, the wound didn't have a lot of blood coming down her face. It was more or less, it looked like a gash, not a surgical wound, but you know, it looked like it had been, I don't know if, you know, there wasn't a lot of blood on her face.
And you're saying you saw her in the bedroom?
I did.
What kind of a flooring was she on?
She was on carpet, I believe.
You're trained in CPR.
I am.
Did you watch the emergency responders performing CPR on her?
For a little bit, yeah.
How did it appear to you?
It appeared that they were doing what we've been trained to do, and it looked like they were doing it as well as I could do it. I didn't feel like I needed to go in and tell them they're doing it wrong and I'd step in for them. No, they appeared to be competent in what they were doing.
Are you familiar with the term patches?
Patches like a medical patch?
Yeah, like when someone is hooked up to machines?
Oh, okay, so like
you
a
familiar with-
defibrillator patch.
Okay.
Yeah, I'm
Was
familiar
she
with
hooked
that.
up to patches at this
Yes,
point?
yes.
And did you see the machine that was going to measure signs of life?
Yes.
How did that appear to you?
The rhythm, if you could call it a rhythm, was waning. We call it agonal in the medical terms, but there wasn't much of a beat that I could distinguish other than maybe what was coming from compressions that can lead someone to believe that something's going on. But
Okay. Did you look in the bathroom at all?
so the bath is, as I recall, right off the bedroom. There's really not much, not a door, not a wall between the bed and the tub. So I could see the tub from where I was standing.
Did you notice anything about the tub?
It was elevated. There was a surround, if you will, around it. It seemed like it was a tile surround. I think it was empty. You know, there was no water in it.
How long were you in the bedroom, bathroom area?
2 to 3 minutes.
And what did you do?
After I could see that they appeared to be handling things appropriately, and they seemed a little bit nervous that I was there doing nothing but, watching. And so I went back out the front door to where Martin was speaking with someone.
And what happened when you went out back by the defendant again?
He handed me a phone and said, tell Alexis, I don't remember what's going on. And at that point, I took the phone from him and spoke with Alexis, who I recall was in the Las Vegas area going to school.
What did you tell her?
I couldn't bring myself to tell her that her mom looked like she was dead, so I just said, you've got to get up here, and fast. You've got to get up here now.
Do you remember telling investigators that the defendant told you, tell Alexis, I can't?
Do I recall someone asking me, can you repeat
You
that,
remember telling investigators that the defendant told you that?
that he can't, oh, like he couldn't break the news to her?
Right.
It said that, yeah.
Do you know Alexis?
I do.
And how do you know her?
Once again, the ballet benefits, it seemed like she performed at more than one. She, at times, also came down to work, to his workplace, and I saw her there. I was introduced to her there, I believe.
Are you familiar with what she was doing in her life around this time?
Medical school in the Las Vegas area, as I recall.
How did the defendant appear to you when you were at the home that early morning, afternoon time?
He was pretty distraught. He was outside with a police officer. The conversation seemed pretty like he was, he was talking with the police officer. I didn't listen in on their conversation per se, but it was pretty animated. I don't know if there was discussion going on there about what should happen here. I don't know.
Do you remember what he was wearing at the house?
It seemed like he was wearing a lab coat that day.
You worked around him a lot at the developmental center.
Uh-huh.
What did he normally wear at the developmental center?
I think he normally wore something like I'm wearing now, a button-down shirt with pants. I don't recall that he wore a suit to work very often, and not scrubs to work very often.
Did you later speak to the defendant about what had happened on April 11th?
I did.
When and where was that?
So because I'd given notice and I was leaving, the next week was kind of my last week there. It was an early morning, and I was kind of surprised to see him back, but we talked for a bit. I don't think there was really anybody else in the building, just because the nature of get to work early kind of situation.
Well, where was this at?
In his office.
And how long did you talk to him?
Oh, it might have been 20, 30 minutes, something like that.
And what did he tell you on this occasion?
I wanted, as I was leaving, so I was interested to know what really happened. I wanted to be sensitive to his feelings, because I thought, wow. But as I was leaving, I thought my opportunity to know anything about anything was waning pretty fast, and so I asked him what happened.
And what did he tell you?
He said, well, I picked up Ada, who attended a private school close to there.
And if I could stop you real quick, who is Ada?
His daughter.
Okay. Go ahead.
And took her home, and Ada ran up the steps into the house and into the room and came back out and said, something's wrong with Mom. Mommy, something's wrong with Mommy. he went into the room and he described it as he saw her face down the wrong way in the tub. And I, I was, we're all shocked about this at this point. And he said he pulled her out of the tub and started performing CPR on her. And that's when, and then he called 911. I don't recall if he told me that he called 911 or I just assumed that. But
He said she was face down in the tub the wrong way.
yeah, clothed, I think he said.
Did he say what the water was like?
He said there was a lot of blood in the water. That's all I recall about that. I don't think he commented as to the temperature or anything like that.
Did he say anything about Michelle having had surgery?
At this point, he said, Michelle had surgery, right? And I don't recall if I'd known before then. It seemed like I hadn't, but he did tell me that she had undergone some cosmetic-like surgery.
Did he tell you what he thought had happened?
I think he let me put the pieces together. I don't think he told me, I think she hit her head, or I think she drowned, or I think he just said, left it at that and let me draw my own conclusions, I think.
You worked with the defendant for a number of years.
Uh-huh.
Did you have the opportunity to observe him moving and working, and how he appeared physically?
Yeah.
Are you aware that he was using a cane at some point?
Yeah, I think it was right before I left. He was using a cane.
Did he tell you why?
Something to do with his toe that had a problem, a medical problem.
Do you know what kind of medical problem?
Seemed like it was, I described it as a peripheral neuropathy that was familial. That just means that a potentially genetic problem that he had in his toe wouldn't get better, that kind of thing.
Okay. Do you know if he sought any treatment for that?
Mm-hmm. He did. He relayed to us that he'd sought medical treatment at the Mayo Clinic, I think down in Arizona, the campus down there.
Did he ever mention cancer to you?
I don't ever recall cancer being brought up as part of his toe.
You said that you met with the defendant following Michelle's death at work.
Yes.
Did you notice anything different about him when he came back?
He came back a little earlier than I would have suspected, but just because you have bereavement days for a close family member, and those weren't exhausted. But
Did you notice anything different about what he was wearing?
Oh, he did have a different ring on his finger, on his left hand, fourth finger.
So on the wedding finger?
Mm-hmm.
Why do you say it was different?
Well, as I recall, he had a wedding band that was somewhat nondescript. It was gold. It was round. Previous to that, and the ring he was wearing at that day had a distinctive black stripe besides it being a gold band, the black artistry on it was definitely different than I used to see it.
So you'd worked with him for 6 years, and he wore one ring, but after he came back, he was wearing a different ring.
Yeah.
How was he in terms of observable emotion when he came back?
He seemed relatively calm. I mean, it was talking about it. I'm always sensitive about speaking about someone's personal life, especially in that context, and he seemed to be taking it Okay.
Have just a minute, Your Honor.
You may. You may cross.
And how are you?
Hello. Well, thanks, Suzanne.
Okay, so you worked at the Developmental Center with Martin.
Yes.
correct? And he was your supervisor,
He was.
and he was on the administrative side of the Developmental Center, correct?
As far as his duties, yes. As far as his office, it was adjacent somewhat to our location.
Okay, but I'm talking about in terms of his duties. He was on the administrative side rather than being a practicing physician, correct?
Well, the person that held his position prior had been a practicing provider just like all of us. And the person that followed him also is a practicing provider just like all of us. And he also filled that role. Now, he had administrative duties, but he also took, for example, stints in the urgent care where he was expected to sew up heads that were split open, treat things of urgent nature, things like that.
So he had a dual role.
Correct.
Okay, that's all I was trying to clear up. And the Developmental Center was for people with mental impairments, correct?
Correct.
You worked with him on a daily basis,
Yes.
and you socialized with him on a limited basis.
Limited, yeah.
Okay, so let's talk about Martin's toe. Isn't it true that the toe started bothering him in 2005 or 2006?
It seems about right.
And that's when he started using a cane.
Initially, he didn't require a cane. In fact, initially he played on the softball team, but as time progressed, I think when I left, he was using a cane.
You testified at a preliminary hearing in this matter?
Yes,
It was about a year ago.
as I recall, yes.
Do you recall saying during the preliminary hearing that Martin started using a cane when the problem with his toe started?
I think he started using a cane, not necessarily at the beginning of when this toe started, but as time progressed, he ended up using a cane.
Okay, and there was a diagnosis of what was wrong with his toe?
That was always the difficulty, and that's why he was going to the Mayo Clinic to try and get a positive diagnosis.
Okay, did he ever tell you about a certain diagnosis?
Objection, hearsay.
Sustained.
But you were familiar that it was a periphery neuropathy, or,
That's what he told me, yeah.
okay, and he told you that that was a genetic thing?
You raising your objection?
I think it's still hearsay, Your Honor.
Sustained. The diagnosis of the defendant's condition is hearsay. You're to disregard the last answer. Go ahead.
He told you that this caused tingling and weakness.
Objection, hearsay.
This is state of mind, Your Honor.
Whose?
The defendant's.
You wish to be heard?
I think a assertion by the defendant has to be offered by the opposing party.
Does the objection sustained?
Okay. May I approach, Your Honor?
You may.
preliminary hearing transcript. You see it there?
I do.
And I asked you the question, when did Martin start using a cane?
Do you want me to read that?
Yes.
About the time that his toe problem came up.
And he sought treatment for this toe problem, like you said?
I think one option for treatment was amputation, which he didn't want to consider.
Okay. And that was a recommendation by a doctor?
Objection, hearsay.
Sustained.
Now, you stated that Martin had gone on code scenes with
Yes.
you?
Mm-hmm.
Okay. None of these scenes required lifting anybody out of a bathtub?
That's correct.
Okay, and didn't require lifting at all for that matter?
There was work involved in a code. It takes more work than maybe you'd think, because there's a body not always positioned the way you need it to be able to do compressions effectively.
Okay, but you didn't, at the preliminary hearing, you testified that you never saw him on a code scene that required lifting anybody, a body, correct?
Right. It's not typical that we would lift bodies. We might roll them over, but we wouldn't lift anybody onto, say, a stretcher. That would be after the ambulance arrives, that kind of thing.
Okay, and I called you and talked to you yesterday, isn't that right?
Yes, thank you.
Okay, and I asked you about how many times you saw Martin do CPR in one of these scenes, and you said that it was only one time, right?
One time in the parking lot that we had talked about, I don't recall another time. It wouldn't surprise me if there was a handful of times, but...
Okay, but when these scenes are called, a bunch of people go out to the scene, right?
Mm-hmm.
And so it's
A
not
bunch,
just
how many is a
Martin,
bunch? You know, the bunch.
but doctors go out to the scene from the developmental center.
There's one doctor at the developmental center, which was Martin,
Okay,
and
and-
nurse practitioners would also go out, and nurses would also go out.
Okay, so Martin wasn't necessarily participating in CPR on all of these code scenes. It may have been somebody else.
Right, right. It's
And-
not always him.
And the only one that you could remember yesterday when you talked to me was the one in the parking lot where you saw him giving breaths to somebody?
The only one that I can remember the specifics of. I think there was more than one that we had been on. But as far as that particular one, I just remember better than others.
And you talked to Doug Whitney in this case,
I did.
an investigator. Was that when was that?
I believe it was in 2009.
Okay, and he asked you if you noticed if Michelle threw up anything while you were in the room.
I think he did ask me that, yeah.
Okay. And you remember telling Doug Whitney that if there's any gunk in the throat, that no matter how hard you blow, you can't get air past that gunk.
Sounds quite technical. Yeah, I think I recall that.
Okay, and what you meant by that is that someone can be doing CPR, and if there's anything in the throat, doesn't matter how hard you blow, you can't get past that.
Right, if somebody's throat is occluded by vomitus or something of that nature, and you breathe into them, of course, that doesn't remove whatever's in the airway, and you may well put that into their lungs, breathe that into their lungs, or something of that nature. So it's important to clear that.
Okay, so that could be vomit, or that could be mucus as well.
Or food, or a foreign body, number of things.
And have you ever worked with an ambu bag?
I have.
Right. And were those taken out to the scene on these code scenes?
Frequently, yes.
And you told me yesterday that you thought that the ambu bag was more efficient than mouth-to-mouth generally?
It is able to give a fuller breath. Yeah, there are advantages why we have an ambu bag, hence they wouldn't.
Okay, and
probably
more
need
air
them.
can be pressed in, isn't that correct?
That's correct.
And then oxygen can be added to that as well.
If one so chooses, if they bring oxygen, oftentimes there's a port to add oxygen.
Okay, which isn't done with mouth-to-mouth, correct?
That's correct.
Okay. Now, you talked about Michelle's surgery. You didn't know specifically that she was having cosmetic surgery, but didn't you know that she was having surgery prior to April 11, 2007?
I had, there was request for a hospital bed, kind of going around from, Martin was asking about one. And it seemed like there was a procedure that was being planned, but I didn't know any details of it.
Okay, but you knew that Martin was looking for a hospital bed,
Yeah, it was asked around, yeah.
and that he had ordered one for
I-
Michelle?
I don't recall how he ascertained it in the end, whether he ordered it or was able to get one. It seemed like he ordered
And
one.
didn't you tell the investigator that the reasons for having a hospital bed, especially in a cosmetic surgery, is that the head is elevated, so that takes pressure off the sutures?
Yeah, specifically if every surgery will be different depending on what is being worked on. But if you had a suture line on the head area, having less pressure on those sutures would be beneficial. Is that what you're asking?
Yes.
Yeah, I don't know firsthand information with regard to this as far as,
I understand, but you
Okay.
told the investigator that.
okay,
Does that sound familiar?
it sounds familiar.
Okay. And when you first arrived at the house, you saw Martin talking with a police officer, you stated?
Yeah,
Okay, and
Yes.
you stated that he was distraught?
he appeared distraught.
Okay, and in fact, you said that he was animated?
Yes,
Okay, do you remember saying that he was just telling Doug Whitney, the investigator, that he was beside himself?
where does Doug Whitney come in to
He's the
this?
investigator, I'm sorry.
Right, but Martin didn't tell Doug anything that I'm aware of.
No, but you told Doug Whitney that
That what?
Martin was beside himself?
Okay, that seems about right for somebody that's very animated and talking to a police officer and shoving a phone in my hand and saying, talk to Alexis. That's kind of the scene that I came on.
And you stated that you didn't sense that he was angry, is that right, in your interview with Doug Whitney? You thought he was more
At the
animated?
house?
Yes, than angry.
Now you're splitting hairs because I think animated is to him a form of possible anger. You know, when Martin's animated, he oftentimes that's how he displays anger.
Okay. And did you detect he was angry that day, or you weren't sure?
I think it was more of a high anxiety. I didn't take it as him being angry at the police officer or anything, but just his anxiety level was such that he was animated, and I don't take that he was angry that day per se.
Okay. Now, you went into the room and you saw Michelle on the carpet, and how long were you in the room?
2 to 3 minutes.
Okay, didn't you say at the preliminary hearing that you were only in the room 1 to 2 minutes?
I could have possibly said that.
Okay, do you still have the prelim transcript up there? Let's see.
I think you
if I
took
can
it
get
back.
to-
There.
You may.
I asked you the question of how long you thought you were in the bedroom. Can you answer that?
1 to 2 minutes.
So you weren't in there a long time at all.
Right. I guess 2 minutes.
You did notice that she was completely naked?
Yeah, she didn't have any clothes on. I didn't see any clothes in the room, in fact.
And you didn't notice her throw up or,
Yeah, I didn't notice that she was wet or had vomitus on her. If she would have thrown up in the carpet, the EMTs might be kneeling in it. I don't know. I didn't.
okay,
I
and you didn't
wasn't.
notice any medication in the room?
I did not notice any medication in the room.
In fact, you didn't even notice the hospital bed.
Yeah, I don't recall if the hospital bed was back in the corner. I was, you're focused on one thing when there's a code.
Sure, and you were
That's what I was
focused on Michelle.
focused on.
Now, when you had this conversation with Martin, you had a conversation about why he was back at work the following Monday, correct?
I think I may have made the comment that, what are you doing back at work? Something along those lines.
And he said he'd rather be sitting around work than sitting...
Objection, hearsay.
Is there any reason? Any exception to the hearsay
No, Your
rule?
Honor.
Sustained.
Martin was pretty involved in work, correct?
Yeah,
And he was a very hard worker,
I would say so.
and he got there early,
Mm-hmm.
and a lot of times he'd leave late,
I think so, yeah.
and sometimes he'd work the weekends,
It wasn't uncommon to see him there on the weekend.
and he wasn't the type that, in your opinion, that, would lounge around or...
Definitely not. In fact, he often had a side job,
Okay.
whether it was at a plasma center or a med spa, those kind of things.
Okay, and this conversation where you talked to Martin, this was a week after Michelle's death?
Seemed like it was just shy of a week, but the next week, yeah.
And you were the one that initiated that conversation, it wasn't Martin?
Right. I went to his office. Like I said, it was an early morning. I think we were maybe the only two in the building. And wanted to send him some condolences. I mean, surprised he's at work. But, and then just a cohort talk.
And you stated that he told you some things about what had happened that morning on April 11, 2007,
That's correct.
but he didn't give you a blow-by-blow account of everything, did he?
No,
He didn't, for example, he didn't tell you what time the police arrived
that's correct.
or when the EMTs arrived?
No, as a matter of fact, he knew when I'd arrived, and I thought it was all in short order. That kind of interesting that when I got there, the police had already got there, being that I was at a campus really close. But he just told me, like, for example, that he pulled her out of the tub and started CPR. He didn't go through the details of that.
Yeah, he didn't tell you that, the neighbors had come over and helped him?
No, in fact, I didn't know that the neighbors had come over from what he told me.
Okay, and he told you that Michelle was face down in the tub?
The wrong way.
Okay, in the wrong way, and he speculated that she had fallen into the tub?
I don't remember if he said that or he just lined up the breadcrumbs for me to, put that into my head that way.
Okay, and he specifically said that she was in the tub?
Yeah, wrong way in the tub.
And he said that there was water in the tub?
Yes.
And that water was bloody, there was a lot of
Correct.
blood, correct?
Yep.
Let's talk about the phone call to Alexis. After leaving the room where Michelle was, you went back out to talk to Martin, correct?
Correct.
And this is when he asked you to talk to Michelle?
Yes. I think I alluded to it earlier. He held out his hand and
I believe the testimony was to Alexis, not Michelle, Your Honor.
I'm sorry, to Alexis.
Sustained, go ahead.
And he was on the phone with Alexis.
Yes.
He was talking to her, and then he handed the phone over to you.
Yes.
And at that point, he was really distraught.
Objection, speculation.
Is this a prior
It's a prior statement. Do you recall telling?
overruled? Go ahead, rephrase.
Okay. At this point, you noticed he was really distraught.
Yeah, I think I used animated or distraught or high anxiety. Yeah, yes.
Ever remember writing out a prescription for Michelle MacNeill in 2002?
You showed me the evidence that I did. I recall vaguely, but the documentation shows that I wrote prescription for
Do
her.
you recall that you gave her 30 pills of Valium on December 31st, 2002?
Yes, as a kind of professional courtesy to Martin.
Okay. And you also prescribed 30 pills of Lortab, which is also hydrocodone, to Michelle MacNeill on that same date?
Yes.
Okay.
I think that was the only time that I'd prescribed for her, but yes.
Okay. And you've stated earlier that you didn't feel that Martin abused your position by asking you to fill that for his wife, right?
Yeah, it's a professional courtesy. I think I was maybe uncomfortable with the quantities, but as a one-time kind of understanding, I did that.
And that's the only time you prescribed for Michelle, correct?
Yes.
Okay. You have one moment, Your Honor.
You may.
I have nothing further, Your Honor.
Do you have cross-exam, or redirect?
I do, Your Honor.
Go ahead.
Can I approach the witness, Your Honor?
You may.
I don't like paper documents, so I'll do everything on my tablet. This is the same portion of the preliminary hearing that Ms. Guston had you read. And you read about that time the toe problem came up is when he started using the cane. Will you read the rest of your answer there?
Yes, about the time that his toe problem came up, but like I said, I don't know the exact date to that.
Okay. You've testified that when you were at the house and you were in front of the house on April 11th of 2007 with the defendant, he was exhibiting what you would say is high anxiety. He was animated. He was distraught.
Correct.
You had worked with him for a number of years prior to this, correct?
Correct.
Was he the same way at the house on that morning that he was at work?
Earlier that morning,
Let me rephrase that.
please.
The high anxiety, the animation, the distraught, observable things you saw on April 11th, is that how he normally acted at work?
Only in rare instances, for example, a code can bring out anxiety, high anxiety in a person.
Okay, did you see him exhibit those same things, high anxiety, animation, and being distraught in coding situations?
Yes.
Okay. You described prescribing pills to Michelle MacNeill as a professional courtesy for the defendant.
Yeah.
Did you personally meet with Michelle about those?
No.
Did you ever see Michelle consume any of those medications?
No.
Okay. So you did this simply because the defendant asked you to?
Correct.
Okay, thank you.
I just have one follow-up question. Back to the cane. May I approach, Your Honor?
You may.
So we were talking about how I asked a question on the prior page that said, when did he start using the cane? And then I came back and you said about the time that his toe problem came up. You answered that. And then the prosecutor had you come back and read another statement. I don't know the exact date due to that. Can you read from here on out?
Okay. Okay, but that would have been in 2006. That's your question. A year before. And I answered something like that, yeah. And you said, okay. And then I said, I don't know if it was 2006 or 2005. It seemed like it was in that time frame.
Okay,
though.
what we're talking about from either 2005 or 2006 is when he started using the king, correct?
Yes.
Nothing further.
I don't have any other questions.
Do you have questions for this witness? You approach, counsel. Mr. Mickelson, the jury has just a couple of questions. Since Martin was your supervisor, did you feel like you had to go to the ballet benefits in order to stay in good favor with him?
I didn't feel like I had to do those things. Oftentimes, the ballet was the reward but I didn't feel like I was obligated to go to those in order to stay in good favor with him as a supervisor.
What was the reason Martin gave in 2002 for Michelle needing Lortab and Valium?
It seemed like she had a hurt neck. It seemed like he'd said something along the lines that she hit her head on the headboard, and that she needed something for pain and to help with this stiff neck. The quantities I was a little uncomfortable with, but as a one-time, till she could get to be seen, I conceded.
Do you have follow-up questions
No, Your Honor.
from the defense? May Mr. Mickelson be stepped down today?
I don't see any reason why we need him to remain under a subpoena.
Does the defense wish to have him remain under subpoena? You're released from your trial subpoena. Thank you. You may step down. You done for the day? Okay. Ladies and gentlemen, during lengthy trials, counsel do their best to anticipate how long witnesses will take, and while people are under subpoena for the entire time, a schedule is in place. We're going to end a few minutes early today. That's all the witnesses that were scheduled for today. Please keep in mind my prior admonition to you. Don't discuss the case or any subject of the trial amongst yourselves or with anyone else, including family members and friends that you'll see this evening. Avoid television, radio, internet news coverage. Don't do any research on your own using computers or something else. And finally, don't form or express any opinion about the case until it's finally submitted to you for deliberation after you've heard all of the evidence that's presented. We will commence in this courtroom tomorrow morning at 8:30. Again, I appreciate your being prompt every day. We do our best to do that as well, and we'll commit that to you. Court's in recess. Thank you. Please be seated. Would you like to take a brief break before we deal with the other matters?
That'd be fine, Your Honor.
Let's be in recess for about 15 minutes.